So yeah, so welcome to everybody who's joined us. I know there's a number of familiar faces and names. If you're new to one of our webinars, we're really pleased to have you along. I'm Nick, and I head the employment team at Actons, and Actons is based out of Nottingham. We work with a number of amazing kind of household name clients that you will have heard of, as well as SMEs across the East Midlands and beyond. And yeah, we do the full range of sort of employment law support, as you would expect. Some of that is managing employee exits. Some of that is TUPE transfers, employment contracts and policies, procedures, managing sickness absence, all those sorts of things, tribunal claims and the like. And yeah, we're excited about today, and we're excited about the future of employment law, because actually there's going to be a lot changing. So it's going to be an interesting time, and we'll come on to some of that. This is the fabulous team. You'll hear from James. You'll hopefully hear from Laura, as we talked about. But we'll see when we get to that point. The suspense is building already. So, plan for today. I just wanted to set the scene a little bit as to why we decided to focus on this. The first reason was we did a little poll on LinkedIn. If you do use LinkedIn, do follow us, connect with us. We do put a lot of information out there. But we did a poll for what should the next webinar topic be, and it was a joint first place for this and TUPE. And James loves TUPE, but I think it's boring. So we decided to go with this. So that was one reason. The other reason was that actually, increasingly, we're seeing a focus on having to manage these kind of situations well, having to manage employee exits well. And that's partly as the drivers for that are that, it's not easy to do business, it's not easy to recruit good people, it's not easy to retain good people, and sometimes actually you will have to part ways, but actually that has an impact on the business and that individual. It has an impact on the colleagues of that person that are going, and it has an impact in terms of legal risk, clearly, and that's the business that we're in. But increasingly we're talking to clients about PR risk as well, because actually it does also result often in a dispute that might spill onto social media, or that the press might even get interested in, if you're a higher profile employer, or if it's a particularly juicy issue, and you can be unfortunate enough to attract attention in a way that perhaps you would prefer not to. So having done it well is important from that perspective, as well as it sets a culture. It's part of your employer brand. It's part of retaining the good people that you have. If you're performance managing somebody well, for example, and they might improve, or the rest of the team look at it and go, okay, they're dealing with underperformance in this team. That's important, within an organization to do well, because it sets a tone, I suppose. And of course, as I alluded to earlier, I think increasingly we are going to see a focus on unfair dismissal in particular, because the new Labour government have promised to reduce the qualifying service, so the length of time that people have to be employed for to be able to bring an unfair dismissal claim, and said that will effectively start from day one, subject to some caveats around probationary periods. And we don't have very much detail on that, but that's coming, and it could be relatively soon. We're thinking probably within the next year. That's a fairly significant change that's going to come. We did a webinar on those changes that Labour were proposing, and we actually did that webinar just ahead of the election, and I don't think a huge amount has changed. And again, Sean's very kindly popped a link to that webinar in the chat, and if you're interested in hearing more about what might be changing in HR and employment law, then do have a watch back of that session. Hopefully that's helpful. So that's kind of setting the scene and looking at why this is important. The plan for today is that we're going to look at briefly some of the common reasons for dismissal, and kind of the common processes, or the fair reasons, as I'll come on to, that the employers rely on for dismissing them, and dismissing people, and a bit about process. We're then, I think, probably going to focus more on the bulk of the session is going to be more about some of those trickier issues that arise when you're managing an exit, and we're going to share some sort of hints and tips and some guidance on that too. Part of the reason for only focusing on the dismissal processes and the reasons in a kind of lighter touch way is, one, some of you will know it and be doing it really well, and two, we've done previous webinars on some of those topics already, and if you're interested in seeing a bit more detail specific to those areas, then again, we'll pop the links in the chat for those, so that can be some separate homework. Before we look at those dismissals, what I thought it was worth doing was just reminding people about the test for unfair dismissal. So at the minute, as we said, someone has to have 2 years employment with you before they're able to bring an unfair dismissal claim in most circumstances. And in order to defend that claim, if they were to bring it against you, you essentially have to look at these 2 bullet points on the slides. The way I often describe it is you have to have a fair reason. The law talks about it as a potentially fair reason, but a fair reason, and they're listed there. And again, you'll be familiar with lots of those. And then it has to be reasonable, essentially. So you have to have followed a fair process, and it has to be substantively fair as well. So that's worth keeping in mind, and we'll kind of not be drilling into too much detail on that, but essentially that's what you're kind of keeping in mind as you go. Of course, the other thing to keep in mind are the awards that can be awarded to employees if they're successful with those claims. And for unfair dismissal, it's generally based on loss of earnings, and the compensatory element of that is capped at the lower of the annual salary, so 12 months salary, or currently £115,115, so 115,115. Sounds a bit like a helpline, but that's how I remember it. And yeah, so that's the kind of financial risk that you're keeping in mind with all of this as well. So first dismissal area, redundancies. So again, something that we're seeing a fair amount of at the minute. As I said when I was setting the scene, that the economic environment is good for some, challenging for many others, and we're certainly seeing in the headlines and in the press, but also within our client base, that there is a degree of restructuring, redundancy going on, where people are looking to be more efficient. The impact of technology is obviously part of that too, and changing the landscape as well. And I think this is still very much in focus. So when it comes to redundancy, one of the things that we would nearly always start with a client is just double checking that redundancy is actually the right answer. So are we actually going to launch a redundancy process? Are there any alternatives? Has that been considered already? And if it hasn't, let's work through those together. Things like offering a voluntary redundancy scheme has some advantages where you're not then having to take people through a compulsory process. The challenge with that side of things is that the wrong people may apply for voluntary redundancy, and that's often a bit of a challenge too if people want to go but you prefer that they didn't. Have we considered things like changing working hours, reducing pay sometimes is the other option, where people are happy to take a pay cut. I say happy in inverted commas, in order to avoid redundancy, but it's possible to agree that to save jobs. Have we looked at stopping recruitment, reducing overtime, filling gaps with temporary workers, that kind of thing, in order to address whatever situation the organisation or the business is facing? If that's not possible and that's not going to get us there, then obviously we're looking to follow a fair redundancy process. And again, there's a whole load of detail to this. There's a whole load of procedural steps. I think it's probably one of the most procedural sort of areas when it comes to following a process. But essentially, we're warning people about the redundancy situation. We're consulting with them over a period of time, with them or representatives if there's lots of people being put at risk. We're adopting then a fair basis for selection, for choosing essentially who remains and who is at risk and continues to be at risk, and eventually might leave the organization as a result of a redundancy dismissal. We're doing things like looking at suitable alternative employment as part of that. Are there other vacancies across the business that would work for those people in order that we can retain them, but their role goes, and that kind of thing. And I think, as I said, it's likely to be an increased focus on that area for lots of organizations, for lots of businesses moving forward. I think we did do a webinar on that one, on that topic separately previously as well. So I think Sean will pop full details of that one in the chat. The other one that we did a webinar on was managing sickness absence. So that will appear too. And yeah, funny story. I shared this on LinkedIn yesterday that we were around at a friend's house for dinner a few years ago, and I have several children, and they were having dinner with our friends' kids, and our friends' kids said, "Oh, my dad, he's a doctor, and he helps sick people get better." And I think at the time, 8-year-old daughter piped up and said, "Oh, my dad, he's a lawyer, and he helps businesses sack sick people." And there was a sort of a silence across the table for a short time, and I squirmed in my seat and then thought, do you know what? She's pretty perceptive, my girl, and she'll go far. So hopefully that's given you all a bit of a chuckle at my expense. But yeah, one of the things that we do help clients with is managing sickness absence situations. Now, it doesn't always result in a dismissal, although by the time it gets to us, often that, it's kind of the last resort situation. And, we are often helping with that kind of situation. But actually, sometimes it's about getting people supported with adjustments and getting them back to work. And we like to try and keep a positive focus on it, despite my daughter's perception of what we do. So just briefly, again, looking at two areas, and again, the webinar goes into way more detail on this separately, but two areas where we tend to focus our attention. One is short-term persistent absence, and that's the odd day here, there, a Monday, a Friday, a repeated thing, tummy bug, sore throat, got the flu, whatever it might be. And it's one of those repeated situations that actually becomes very disruptive for an employer, because you can't really rely on whether the person's going to be there or not. And sometimes actually that's more difficult to deal with than a period of solid longer term absence. So again, the way we would generally approach that is to encourage an employer to focus and consult with the employee on those issues, those absences. Return to work meetings, again, they kind of go in and out of fashion a little bit, and different clients of ours like them, love them, some hate them and don't do them. We certainly would encourage those on the basis that it's a marker for someone to have to come and sit with a manager and explain why they were off. It's also an opportunity for the manager to understand what's actually going on with that person. It's also an opportunity for them to take a view on whether there's any support that would be helpful. And I suppose the other thing that it's useful for is that kind of second main bullet point, which is identifying what's actually happening, reviewing that pattern of absence, what's going on, and is there anything else going on that isn't immediately available, like an underlying health condition, for example, on the basis that actually that might be more serious. It might appear that it's a pattern of unrelated illnesses that the person has been off work for, but actually perhaps they have something else going on, like a more serious mental health issue that's causing them to feel that way, or to pretend that they've got those things, but they're not happy talking about it. Or perhaps it's some sort of immune system issue that actually is causing them to get unwell in a variety of different ways, but actually from a risk perspective could cause you more difficulties, particularly if it was to be a disability that you were having to then manage moving forward. So I think that's important. Things like warnings, as a result of a certain number of absences, people have different, again, trigger points in their policies and procedures. Some people might use things like the Bradford factor, that kind of thing. But escalating a series of warnings for that kind of absence is a helpful way, and then taking a view on whether it's actually improving. So again, a difficult one, I think, to manage sometimes, but not at all impossible. The other area, of course, is long-term sickness absence, and that's an area that we focus a lot on with clients because of the significant disruption there is of having somebody off for long periods of time. And usually, as a result of that, the risk is slightly higher because it tends to be a serious condition, which might well constitute a disability under the Equality Act. So again, the webinar that we did previously goes into a lot of detail on the kind of methodology that we have for addressing these kind of issues. But essentially, what we're looking to do here is consult with the employee again. So talk to them about what's going on, make sure we get good updates for them, make sure that we've considered reasonable adjustments as part of that. And you'll see on the slide, I've probably mentioned medical advice more times than I should have done. But it's just so key to this particular area. And I know that a lot of clients have issues with their occupational health provider. I have to be very careful because I can quite easily get into trouble, talking negatively about occupational health. But many of you will be familiar with getting poor reports from occupational health or from GPs, which are not particularly helpful, and say things like the employee will be off for the foreseeable future or things like that. And who knows what that actually means, how long that is. It gives no certainty whatsoever. And I think the thing that I would encourage you to think about is that actually it's not always their fault. I'm trying to be kind to them in this particular session, but it's not always their fault because sometimes they're not asked questions in the right way. And in our referral forms, we kind of trot out the standard occupational health referral questions, and we get the standard response back from them. And lots of the work that we do with clients is helping them improve the quality of the questions in the expectation that they will get better answers as a result of asking things in the right way. And the medical advice is just so key to managing those situations because you're not an expert in whatever condition that they have, unless of course you are by chance. But generally speaking, most of us are not. And neither is the employee. The employee probably won't really even know what's going on for them, despite them experiencing it. They don't know what the long-term issues might be or what the side effects of the medication they have or whatever it might be. Those medical views are really, really important. So we're factoring that into the process, and then we're balancing the needs of the individual and the needs of the business is the way that I describe it. And I think that business need often gets lost in this process. And again, I would encourage you to focus on that more as you're managing these and actually sharing with occupational health the impact that that person being off work has on the business and the team and the cost involved. Talk about the things that you have done. Just don't rely on the employee going and telling them how terribly things have been going, at work. Share with occupational health all the stuff that you've been doing to support that employee, the adjustments that you've considered already, all that kind of stuff, and look at the impact, as I say, that absence is having, and ideally link it to some business need in the future where you need that person back and you need the whole team functioning well, with a view to getting some certainty from the medic as to whether the person will be back. So it feels like an incredibly headline way of describing all of that, but hopefully that's helpful and encourages you to go look at the webinar if that's an issue that you're kind of grappling with. James knows that I could probably talk for about 4 hours on that particular topic, but I am trying to keep it under control. And in fact, I'll hand over to him now to take us on to the next section.
Yeah, thanks, Nick. Morning, everyone. So my first few slides are on performance dismissals, just a similar theme to Nick, just moving at a different reason why you might be in a situation where you were moving towards a dismissal. First point is always important, making sure that if you are relying on a potentially fair reason, that you don't get in a muddle as to which one it is. And if you're saying it's a performance issue, that's a capability reason. It's not a conduct reason. The way I try and distinguish this is sort of, if anyone remembers the TV show from quite a few years ago, Can't Cook, Won't Cook. It's not like that, but performance is that they can't do it. Conduct would be if they won't do it. Lot of similarities with some of the other reasons Nick's already talked about in terms of a positive outlook. So if you have a performance issue, although this webinar is about exits, that shouldn't be the focus. It should be about addressing the actual problem How do we do that? Well, we identify it, we talk to the employer about it, we agree steps to try and improve it, and we keep it watched and we monitor it. Procedure is always helpful just to keep everyone on track. Often, if employers have a kind of capability disciplinary procedure, it can be quite unhelpful for performance management. It sort of stigmatizes it as something that somebody's doing wrong, whereas performance management should be a bit more collaborative. So it's ideally better to have sort of a bespoke performance management procedure that uses more appropriate language than sort of warnings and misconduct when it just simply isn't correct. It's just needing to improve, improvement notes, and think terminology like that it tends to be better. There's a few other notes on the slide. What do we need to be doing? We need to be trying supporting the employee, identifying whether it's that they can't do it because they've not had adequate training, or that would be a solution to the problem. And although this webinar is not about disability, you can get away from that in the employment context. You need to be mindful of it. So are the performance issues arising from an underlying disability? If that's the case, or is at least potentially the case, you need to be looking into that before you potentially get into a tangle. Timescales, as with all areas of unfair dismissal, is that magic word reasonableness. And so it's not possible for me to say what timescales are reasonable in any given context. That's something you have to judge on a case-by-case basis. And as I said before, keeping things under review. And if performance doesn't improve, then you can work through procedures that give warnings and ultimately could lead to dismissal. This is probably the area that least results in dismissals. I think I've had one poor performance, unfair dismissal go all the way to a tribunal in over 10 years of doing tribunal claims, whereas I have absolutely no idea how many I've had for misconduct or redundancy or long-term sick, a lot more. But nevertheless, managing performance works usually for one of three reasons. One is the happy scenario where performance goes up and you don't have a problem anymore. The second is because the employee isn't really engaged, or they're not that interested in improving their performance, or they're just in a role that's not suitable for them. And if you manage it, it often drives them to think, actually, I'd be better doing a different job. And they move on, and the problem in a certain respect resolves itself from an employment risk perspective. They resign and work elsewhere. Or the third, and this sort of leads into the meat of the session we'll get to in a minute, is if you are managing performance actively, often if you do want to try and speed things along and not work through the stages of a process to get to the end, which is usually quite time consuming in a performance context, it might mean that you can come to some kind of agreement. But the fact you're actually managing the process will mean that the employee can see that there's a potential end, there's a carrot, and I'll come back to that sort of strategies later on in the main bits of the session. Conduct dismissals is the final type of dismissal or reason why you might be in a scenario that we're looking at today. Probably the one everyone's most familiar with, so I'll do this one the fastest. As you know, it can range from a single serious act, gross misconduct, or a series of less serious acts that either taken together constitute gross misconduct or result in a series of warnings, first warning, final warning, dismissal. Usually disciplinary procedures and policies actually have helpful lists of things that will normally be considered misconduct and things that will normally be considered gross misconduct. Always useful to cross-refer to that, because if you're treating it as something that it's listed in the other category of the list, you might need to have a good reason why. Those lists aren't set in stone, you aren't bound by them, but if it's your policy, the employee, the tribunal, the trade union, whoever's involved is going to look at it, and you should be doing that too, just so you don't get caught out. Is an informal discussion sufficient? Depends on the level of the conduct. But it's always worth thinking, do we need to make this into more of a deal than it is, or can it be nipped in the bud fairly easily? Bullet points on things you're probably quite familiar with in terms of investigation: establish the facts, investigate, keep an open mind. The ACAS code encourages you to look for both guilt in the employee and innocence. If you do one or the other, then your investigation is potentially going to be unfair or seen as biased or inadequate. The scope should be proportionate. So if this is a potentially career-ending piece of misconduct, then an employment tribunal is going to expect you to have performed a more thorough investigation than if it's somewhat more minor issue where the worst case is potentially going to be a warning. And suspension, always a bit of a grey area where people can get confused. Probably the worst thing you can do is have a sort of knee-jerk reaction. In this scenario, we always suspend. In this scenario, we don't. What you need to be doing is considering whether suspension in any given case is appropriate. Why are you suspending? If you don't know why you're suspending, you probably shouldn't be doing it. Usual reasons are that they might be able to interfere with the investigation. They might be able to tamper with witnesses. They might be able to do more of the thing that you think they might have done. So if you're concerned that they might be, say, stealing, then clearly you don't want to continue the risk that they'll carry on doing that whilst in post. But on the flip side, if you don't have a reason for suspension, then you probably ought not to be doing it. It creates its own risk. And if you do go down a disciplinary procedure in a misconduct case, this slide sets out the key bullet points of the things you want to be doing. And you'll be pleased to hear in this area, at least, the old case law still really reigns supreme. There's been a few sort of tweaks and moderations over the years, but if you're following the guidance of BHS and Birchall, whereby if you're reaching a dismissal point, if you can establish that you've got a genuine and honestly held belief in the employee's guilt, that you've based that belief on reasonable grounds, and those reasonable grounds follow on from having undertaken a reasonable investigation to establish the evidence, then you're going to be in a good place to potentially defend an unfair dismissal claim. And then in terms of the severity of the sanction, the decision to dismiss, the case you're probably all familiar with, it, if not in the name, in the concept, is Iceland Frozen Food and Jones. Is the dismissal or the decision to dismiss within the range of so-called reasonable responses? Is dismissal an action a reasonable employer could have taken? The one good thing about unfair dismissal from the employer's side, there's many good things about it really, but that's the nature of that test. The employment tribunal isn't allowed to say, well, actually, we think it was a bit harsh. We wouldn't have dismissed for that. That's substituting their decision for yours. They can't do that. They just have to assess objectively whether the decision you as the employer took one a reasonable employer could have taken, which isn't too bad. And I say that in the knowledge that you might all be facing day one unfair dismissal rights. So let's look at it from the positive side. Those sections we've just covered on the various reasons why you might be moving to the exit route are really the background. The main part of today's session on employee exits are what we've somewhat vaguely described as other options. What do I mean? Well, what I mean is settlement negotiations, and that's what we're going to focus most of today on, because I suspect most employers have been through some kind of negotiation with an employee, but we can hopefully share a bit of insight, having either done that or advised on lots and lots and lots of these and seen how it can be done well, how it can be done badly, what works, what doesn't work. And I've got some really kind of common sense tips to start with. And my section is really about planning. It's the classic case of if you do some good preparation, it'll go a lot better than if you sort of just dive in a hurry, and you could potentially get into a tangle. So what should you be doing? Well, firstly, work out what your objectives are. If you're entering into settlement negotiations, what do you want to achieve and why are you doing that? It might be that you want to enter into the negotiations to avoid the need to go through one of the formal processes that Nick and I have looked at based on redundancy, conduct, whatever it is. Why do you want to avoid those processes? Is it speed? Are there commercial reasons? Does it tie up too many senior people in the business? Is it a case that the workplace morale is damaged by the process dragging on and you want to expedite the process? Are there other reasons? There could be any number of reasons, but it's always good to know why you're doing something before you do it so that you can then tailor your negotiating strategy or your approach to those reasons. What are the circumstances surrounding the offer? That's why we did the background section talking at conduct, redundancy, because that context is key when you're looking at negotiating. What potential claims could arise? Is it unfair dismissal? Is there a risk of, say, a disability discrimination case? What's the potentially fair reason we could rely on if we went down an internal process route? That then lead on to questions like how long would that take? What would be the value of a claim where it to succeed? What is the risk of a claim? And these are all factors you can think about when deciding when and whether to negotiate, and when you do negotiate, where to pitch your offer. A useful starting point is probably the person's contractual terms. Other than in a gross misconduct scenario where you will be entitled, if the employee has committed gross misconduct, to terminate the contract without notice and therefore without notice pay, all the other termination scenarios, there's going to be an obligation on you to either give notice under the contract, or if you have the right in the contract, to make a payment in lieu of notice. So that's usually a sensible starting point in most scenarios. And as I alluded to at the start with the objectives, timescale. What timescale are you looking at? Is this an ASAP situation because we need to move on? Or actually, is this a situation where the employee, you'd like them to move on, or there's a reason why they're moving on, but there could be an effective handover process? Do you need them to tidy things up before they leave? Have you actually lined up a replacement, but they can't start for a while and you need to bridge the gap? There could be any number of factors in play, and you need to make sure you're mindful of those and dovetailing them into your settlement strategy if you're doing settlement. So planning your offer. I touched on notice periods already. So are you looking to pay in lieu of notice? Or is there an issue of the person potentially going to a competitor? Or are there other reasons why you might want to put them on garden leave? If you do want to put them on garden leave, does your contract actually give you the right to do that? You might want to check. But it's always worth considering it. And remember, if you put them on garden leave, probably the main advantage or potential advantage of doing that is that they remain employed. So they wouldn't get the payment in lieu of notice, but you would have a level of control over them for the garden leave period, whether that's just knowing that they can't work for somebody else, or that you could potentially contact them for minor queries, or you forgot the password, or can you give us the login? As they're still employed, you can reasonably ask them to do things like that when they're on garden leave. The other thing that often comes up in negotiations, benefits during the notice period. If someone's on garden leave, then they'll continue to get their contractual benefits. But if they're not, they're immediately leaving. Are we going to offer them things like their company car, or do they have to give that back immediately upon termination? Things to factor in, things that the employer might be interested in. Similarly, holiday. How much has been accrued and not taken? If you're sitting on someone with a big pile of holiday and you don't want to pay out, maybe you look to use garden leave to sort of minimize the cost of that by having them take their holiday whilst they're on garden leave, so there's no payment in lieu of holiday due on termination. Or maybe you factor that into the timings of the offer. The other thing about holiday is making sure you're mindful of it. Sometimes employers think, well, we'll just agree a leave date and we'll just wipe off the holiday, but that might have adverse consequences for tax. With the revenue thinking, well, you can't do that. You're just dressing up a termination payment when really it's just paying them the holiday they're owed. So don't forget about holiday in any deal. If it's a cost you have to bear, work out what it is and how you might be able to manage it, either by garden leave or by factoring it into other payments you might need to make. Other types of leave, sometimes you can have a quirky situation where the employee is just about to go on maternity leave and you'll owe them SMP. Do you want to be paying that as a lump sum? How much is that? And if they're in a situation where maybe they're off sick, what are you doing about that? So you're going to pay them sick leave for a time, and then does the rest of the offer come in, or is the offer that they'll be paid in full even though they're on sick leave? So think through these types of issues before you enter into the negotiations, so you know where you stand and what your position is going to be. Other things, when you're planning your offer, considerations, legal cost contribution. Later in the talk, we'll talk about settlement agreements. As I'm sure you all know, for an employee to enter into a settlement agreement that validly waives their employment rights, they need to have independent legal advice. That has a cost. The employer doesn't have to bear that cost, but they normally do for reasons of practicality. What is that cost? Well, these days, you'll be struggling to get advice on a settlement agreement for less than £500 plus VAT, unless it's the most sort of cursory, this is what it says and nothing more, which is quite rare these days. I remember when I started out 10 years ago or more, that £250 plus VAT's the standard. So I was thinking about that in terms of how much everything's gone up. I suspect that going from 250 to 500 in about 10 to 15 years is actually sort of a below everything else rate of increase. So you should bear that cost in mind. I mentioned continuing benefits earlier. Bonus payments, they're always an interesting one. Again, I'm going to repeat myself. The contract is the starting point. Many a clause in a contract these days will say you aren't entitled to the bonus payment unless you're still employed on the date that it's paid, and or you aren't entitled to it if you've been given or are serving notice prior to the point of payment. If that's the case, then make sure you know that before you're entering into negotiations, because you can factor that in as to whether you offer bonus or whether you say you're not entitled to bonus and factor it into another part of your offer. Outplacement support, some people really don't like that because it's not cash up front. They get a service that they can then recoup the cost of by providing an invoice. Some people really like it. It is quite a tax efficient way of doing things if the settlement is a large one. So it's always something to consider that might be of value to the employee and might be something that can get a deal over the line. And similarly, references and announcements. Often employees or employers are really keen on these, and they're things that are much harder to achieve in a litigation context. So there can be some mutual benefit there, and it can be something that can help reach agreement. Tax. This isn't a tax seminar, but it's a planning seminar in terms of the context of settlement. And if you don't think about tax, you can get into a bit of a tangle. So what do I mean by avoid the tax-free trap? Well, the thing I come across more frequently than perhaps I ought to is where employer and employee have had a discussion, and this can be where I'm acting for either side, and I'm presented with a deal, and everyone's very happy with the deal because the employee's been told he's going to get a big lump of cash tax-free, and the employer's pleased because they're going to pay the lump of cash tax-free, and nobody pays any tax, and everyone's a winner. And then unfortunately they go to the solicitors, and someone like me will say, well, that's all well and good that you've all agreed that, and everyone's very happy, but it just simply doesn't work. Tax will be due on those payments. You've agreed something that can't be agreed, and if Revenue and Customs looked into this, then they're going to be looking to get their tax, and somebody's going to have to pay. And often then you end up in a situation where one party is then renegotiating, and both parties are grumpy because somebody has to be the somebody who's going to have to pay the tax. So how do we avoid that? Well, as with anything, we plan and work it out beforehand. So as I said, this is just a summary of the basics, but the first thing to do when you think about tax is, what is the payment? Is the most important word there. What is the payment? Not what are we calling the payment. You can call things what you like, but it's what it is what matters in the eyes of HMRC. So is the payment taxable as normal earnings? What's taxable as normal earnings? Things like wages, holiday pay, notice pay, bonus payments that you're due. Those things are taxable as normal earnings. I often hear clients talking about ex gratia payments, and sometimes in one context, sometimes in another. Some people think an ex gratia payment is sort of a magical way of avoiding tax. It's not the case. There's no real legal definition of an ex gratia payment. It's more of a sort of slangy term that people use. I particularly dislike it and try and avoid using it like the plague, because it means one thing to one person and one thing to another. So if you start using it in negotiations, it's eminently possible that somebody will get the wrong end of the stick. So try and avoid that term would be my tip. The other thing that people commonly like to try and do, which when we come on to the next slide, I'll explain why doesn't work, is trying to backdate notice, where essentially you start negotiating on the 1st of the month and you finish negotiating on the last of the month, and you agree at the end of the month, well, we'll just call the last month the notice period, if it was, say, 1 month. That doesn't work. You can't backdate the notice. If the employer is giving notice, they have to give notice by informing the employee that they're serving notice under the contract, and usually the contract will require that to be in writing. And in any case, as you'd expect as a lawyer, in the event of a dispute, I'd want it to be in writing so you can prove it happened. If you were able to just agree that notice had been worked in any given case, employers and employees up and down the land would be doing that willy-nilly to try and avoid paying tax. So be mindful of that trap of seeking to backdate notice. it really doesn't work. Similarly, waiving rights to holiday and holiday pay that are contractually clear, that's not going to work either for similar reasons. HMRC is not going to think, well, that's all just fine that they've agreed to waive all these taxable payments in lieu of make a tax-free payment. It's simply not going to be very persuasive. And Sian has actually preempted the next slide where I talk about the dreaded concept of post-employment notice pay by sticking a link to the LinkedIn article I did a couple of months back on that. That article goes into more detail than I'm going to go in now, but it's worth reminding everyone what post-employment notice pay is. Post-employment notice pay is another reason why you might not be able to pay employees a sum of money tax-free on termination. So the way I work through is the payment made on termination of employment? If it is, then you can potentially access the termination payments tax regime where the first 30,000 is tax-free. But firstly, you have to rule out the termination payment being taxable for one of the reasons on the previous slide, that it's earnings, because it's notice pay, holiday pay, a bonus payment paid on termination, something like that. So it has to be not one of those, and it also has to not be post-employment notice pay. Now, this is a concept that came in April 2018 and still is sometimes missed. I think probably because the old regime lasted for so long that this was quite a radical change. So I guess 6 and a bit years is, in the context of this, not that old. But what is it? It's, as I said, it's a sort of a gateway. It's where if you have a sum paid on termination that isn't taxable, as one of the things I already said, you have to check whether or not it's post-employment notice pay. How do you do that? You apply the dreaded PEMP formula. There are more than one. I've put one of them on the slide. The reason they're more than one, because as you're probably all familiar, people's salaries are paid slightly differently. Certain people are paid weekly, certain people are paid monthly, and they developed HMRC different formulae to cover different scenario to make it easier. What are the elements of the formula? The one on the slide anyway. BP is the basic pay for the last pay period prior to notice being served by one party. D is the unworked period of notice. P is the number of days in the pay period. So if you're paid monthly, that's 28, 29, 30 or 31, depending on the month. Or if it's weekly, it's 7, happily. And T is amounts paid on termination of employment other than things like holiday and bonuses that is taxable as earnings. So the most common by far of that is a payment in lieu of notice. And when you input these numbers into the formula, if you get a positive number, that amount of money, if you're making termination payment, is taxable as earnings as post-employment notice pay. So if you'd agreed to pay someone £10,000 tax-free, but you did the PEMP calculation and the answer you got was 100, you could in fact only pay them 9,900 tax-free, and £100 would be taxable as earnings. So that's where the tangles can arise. One of the common traps that I've highlighted in the slide is resignations, and the problem with resignations is often the amount of notice the employee has to give to resign is shorter than the amount of notice the employer would have to give the employee to terminate the contract. And the unworked period of notice, D, relates to the employer's notice period, regardless of which party actually terminates the contract. So in that discrepancy situation, an employee and employer can think, well, the employees resigned and worked their entire notice, therefore there's no PEMP because D is 0, because there's no unworked period notice, and that would be wrong because the notice period perhaps, well, I said it would be wrong, it could be wrong because the unworked period of notice could be, say, 2 months because the employee only had to give a month's notice to resign, but was entitled to 3 months notice under his contract. So you can get into a tangle. So my solution to this isn't a brilliant one because it's complicated, but it's just make sure you run your PEMP calculation before you start offering money tax-free, or you say, we think we can offer this tax-free, but it's subject to there being any post-employment notice pay, and you hedge your bets. Because the other situation where PEMP can arise and trip people up, it's quite common, there's probably more than one, is salary sacrifice arrangements, because the BP is based on the pre-sacrifice salary, whereas your pylon might be based on your post-salary sacrifice. So if you work that through, if BP is higher than the T figure isn't going to extinguish the bit in the brackets, and you'll be left with a positive number. But enough about PEMP. And as I said, if that was bamboozling, then you can get a cold towel and read my article. Consider the bargaining position. Back to more general points, tactics. I always think if you're the employer or the employee, but particularly the employer, you need to be thinking, what is the incentive on the employee to reach the agreement? Why would they say yes? And usually the yes is because it's better than the alternative. And the alternative might be continuing on with the internal process. That could be worse for them because, say, it could lead to their dismissal, or it could take time, or it could be unpleasant in certain ways. I mean, not in an oppressive way, but it might not be enjoyable to go through a series of meetings. Or the prospect of litigation. They might think, well, I've got a claim, but it's not that good of a claim, or it's uncertain. Or they might know that the employment tribunal system is very slow and they could be waiting 2 years. So that might be why they want to enter into the agreement. But you need to be thinking, will they do that? Because the alternative they might be thinking is, well, nothing's going to happen in the short term. I'll just say no for now, stall, keep getting my salary, and there's nothing driving them to reach the agreement. So you need to think about what they're likely to do and why, because then you can adjust your strategy accordingly. What is your plan B? I think the biggest mistake employers can have is not having one, because as I said, then the employer can somewhat drive a hard bargain, sorry, the employee, and say, well, no deal, I just want more money. And if you don't have a plan B, you sometimes get into a situation where your only option is just to keep adding more money to the negotiation, which you're probably not going to want to do, or caving in on other points where you don't want to cave. It doesn't always have to be about money. So have a plan B, whether that's to carry on with internal processes, go down a different route, just proceed to dismiss and face the consequences of a claim. Think about what your plan B is and have it up your sleeve. If plan A is negotiating and that's not working, then be prepared to either move to plan B or at least start on plan B with the hope of reverting back to plan A as plan B progresses. And that's what I mean by interaction of parallel processes. If you suspend someone on potential misconduct and you offer them a settlement straight away, the employee might say, well, no, I've done nothing wrong, I'm not entering into the agreement. But if you investigate for 2 weeks, gather in a whole load of evidence that shows they're probably banged to rights, and invite them to a disciplinary hearing, and closing all that evidence, the offer that you previously made that they rejected, they might now be thinking is a very good offer indeed. So that's how what I mean pulling the two slices together, what I mean by your plan B. Sometimes if you've got parallel processes going on, whether that's performance management, redundancy, but you really want to enter into an agreement, carrying on with the parallel process is usually, not always, your best bargaining chip in terms of getting the employee to do a deal with you, and showing that what you're doing isn't potentially unfair, and then you're quite happy to do it. And in fact, the offer is good for them as well as you, or just for them. So that's planning. The next part is going to be more about how we close it off. And hopefully Laura's going to be back, but if not, Nick's going to jump in.
So Laura, are you out there? I'm guessing that's a no. Okay, let's go for it. So actually having settlement conversations. So James has set out the sort of planning session section, and we're going to talk about actually some of the mechanics of that now. And in fact, I was chatting to a client just yesterday about this exact issue, so it's fresh in the mind. And the fact that Laura was prevented from talking to you about it all as a result of her IT issues today is no problem. We'll crack on. So the different types of conversations that you might utilize when it comes to settlement negotiations are on the slide here. And one of those is protected conversation, or pre-termination negotiation, as it's sometimes called. And the other is without prejudice. And you probably will have heard both of those used. It may be that you don't really know the difference. It may be that they're being used incorrectly to cover the wrong situations. And to some extent, that doesn't matter. To some extent, it does really matter from a legal perspective. So it's worth just having an understanding of what each of them means and when it's best to use those particular things. So First of all, protected conversations. This is some legislation that was brought in to allow employers to have conversations with their employees ahead of them being dismissed about things like the fact that they're underperforming, or that there's a misconduct issue that, like James was explaining, and have a discussion about the fact that they might have an alternative, which is a kind of agreed exit, usually involving a settlement agreement. That generally takes place before termination of employment, and that's the key bit to remember here, I suppose. More often, without prejudice is relevant after someone has been dismissed, so after termination of employment, and that's because there has to be an existing dispute. So where legal proceedings are either in play or they're contemplated, and the most obvious time where that's the case is when the person's been dismissed. Now, it can be that you've got a legal dispute at the point someone raises a grievance alleging discrimination and threatening to sue you and that kind of thing. But generally speaking, the distinction I usually use is protected conversations will take place before dismissal. Without prejudice, discussions usually take place after dismissal. And those kind of scenarios are things that you will be familiar with, and kind of dilemmas to a certain extent that you have had to navigate. There is an ACAS code of practice on settlement agreements and a guide to settlement agreements that includes detail on the protected conversation regime, and again that might appear in the chat. That's actually quite a user-friendly document and worth a look at in terms of getting the full detail on protected conversations in particular. So in terms of next slide, there are a few things just to keep in mind when we're having those conversations. The idea of these conversations is they're sort of off the record, in inverted commas, and that therefore they can't be referred to further down the line if an employee brings claims against you. But there are a few caveats to that, particularly in the protected conversations regime, where generally speaking, the idea is that it will only apply to discussions or the cover that you get that makes it off the record will only apply in unfair dismissal claims, not discrimination claims. And also, if the employee alleges things like improper behaviour or unambiguous impropriety, almost made it through saying that properly, which you'll see on the slide, you can see that there. Sorry, I think Alison's just pointed out the slides may not be moving for everybody. Is that helpful now? Yeah, but hopefully you can see that. Yeah, we've got a thumbs up. Great. So I think the key really is remembering that it will cover you to a certain extent, the protected conversation regime. And to be honest, most people still use it, even if there is a kind of discrimination angle. And there's the potential of a claim down the track, because you're not really left with many other options if you want to initiate a discussion with an employee about settlement in this way. And in reality, the test for improper behavior and unambiguous impropriety are pretty high, as in it has to be that you're harassing the employee, or you're placing them under undue pressure to either enter into the discussion or to settle, with you. And that, if as long as you're running those processes in a kind of fair and measured way, you'd hope that you won't get to a point where that's the case. So the protection does apply in those scenarios. The other thing that you might do is label up your correspondence or your discussions on these issues as both protected conversation and without prejudice, if you're not sure, or you'd like to have the potential of relying on those things in the future. The key is they will either be protected or they won't. So just labeling things that way won't necessarily make them that way. There are legal tests, as we've sort of talked about, as to whether they actually apply or not. But it is better to be safe, you know, and label it up if you're seeking to rely on that protection at some point. In terms of some more of the fine detail of actually having these discussions for a protected conversation, you're generally asking the employee if they're okay to enter into that discussion. And if they say no, then essentially you can't have that conversation with them. Usually employees are open to having that discussion on the basis that they're curious as to what, you know, what would be said. So I think more often than not, it's you know, it's easy-ish to persuade people that it's worth at least hearing you out. And without prejudice discussions often are taking place after dismissal, and there's less sort of onus on you to ask permission. You're more likely just to be making an offer on that basis. So actually, you know, that's sort of less relevant in that scenario. And essentially, for the protected conversation, if they've said yes, that they are open to that conversation, then essentially you're saying, look, we'd like to talk about a proposal where your employment would come to an end on agreed terms. Usually, and as James was talking, because we're running a parallel process, we're also then saying it's without the need for us to go through this other process. So it might be that we're not going to go through a redundancy process or a disciplinary or continued performance management or that kind of thing. And that's that incentive that, you know, we have there that allows or you know, potentially encourages the employee to take the offer seriously. And as the slide suggests, with for without prejudice, it's about resolving the dispute on agreed terms. And again, that will take a very similar sort of format in terms of what we're offering, you know, as part of a settlement, but it's usually taking place afterwards. Again, James has done the planning session earlier in the webinar, but being prepared for those discussions is obviously really important. Or if you're not doing them, preparing managers for having those discussions is particularly important. So we would nearly always help clients with a script for that meeting so they know what they're covering, the open part of that meeting, as we often describe it, the protected part of that meeting. And then usually, because it helps keep everybody on the same page, we would suggest having an offer letter, so a letter to the employee, which sets out the terms of the offer that you're making. Sometimes that allows you just to slide a letter across the table, you know, to the employee, and they can read through it with you, and you can highlight the key terms. It's important then for them to be able to take it away, because it allows them to you know, in what will no doubt be an emotional or stressful situation for them, because this is likely to come out of the blue. They will at least have a record of what was actually said, what the offer actually was, and that's really important. And sometimes it may also be the case that you provide them with a copy of a settlement agreement with the offer letter at that point, and the letter effectively refers to the settlement agreement being enclosed. That's usually if, you know, if you think the employee would benefit from seeing the detail of the you know, what you're asking them to sign up to. Sometimes that will follow at the point you get an indication from the employee that they're open to agreeing the headline terms that are set out in the offer letter. But actually, sometimes it's worth, you know, providing them with all of the information in order that they can see what they're being asked to agree to. So that's that section. In terms of some other detail, you're usually going to be emphasizing that the offer is being made subject to the employee agreeing settlement terms, and that might well be either a standard form settlement agreement, a longer document, or what's called a COT3, which is a shorter form, usually shorter form settlement agreement agreed via ACAS. And I think James in the second bit of Laura's session will cover a bit more detail on those. And you're also usually emphasizing that there'll be some sort of confidentiality around the agreement. And again, the exact wording of that would usually be included in the settlement agreement and can vary depending on how tight, you know, you want to be on that front. You're nearly always going to set a timescale for accepting the offer. Again, as James was talking about, managing that process to ensure that the employee responds to you and feels you know, the need to do that rather than just stringing things out is a good idea. I think the ACAS code in this area suggests that you should give 10 days from the point at which the offer is given in writing. Again, strictly speaking, to get the protection, that's what you should do. It's rare, if I'm entirely honest with you, that clients are prepared to wait that long for someone to respond on an offer, and sometimes will take a risk on the timescale and set a shorter deadline there, knowing that in theory that's a breach of the kind of regime, but taking a chance on that, because actually to wait 10 days in a scenario where you've put this kind of offer to an employee can be a long time. And I suppose the other things to emphasize, again, partly because they're in the code of practice, is that there is no obligation on the employee to accept the offer, and we should be stating that, and that we're clear from the employer side that it won't influence any process that might follow. So if there is a disciplinary to come, or a redundancy to come, or whatever it might be, whatever negotiations have taken place as part of the protected conversation in particular won't influence our decision on that moving forward. Now, again, we can say that and we can take that approach. It's useful, I think, to consider the mind of the employee. You can well imagine that if the employer has said, we would like you to go under these agreed terms because we think you're likely to be dismissed at these meetings, and we have to be careful about how far we go with saying that kind of thing, but you can understand why the employee might well have difficulty believing that actually the outcome, further down the line of that process, that formal internal process that eventually dismisses them, will be fair, and that is part of the challenge in this scenario. The other thing to keep in mind is the employee may well want to negotiate. It's almost a human nature thing, isn't it? I think I can get a better deal. I'd like to improve on what I've been offered, and therefore, as part of the planning that James described, you might well decide that you have a budget for settlement, and that you have a top figure in mind, but that you don't necessarily put that as your opening offer as part of the initial offer, on the basis that that you're going to have to do some negotiation. Again, depends on the individuals involved, depends on the business and the way that you want to approach it. We certainly have had clients who've just said, look, we're going to put our best offer on the table. If they want to take it, then they can take it. If they don't, then that's fine. We'll move on with the internal process. We're not into that sort of negotiating or horse trading. But certainly our experience is that most employees and most representatives, if they go and get advice, will expect to be a level of negotiation as part of that process, and it might well be worth considering that and building it in as part of your planning. Okay, I think James is going to pick up the second section of settlement agreements.
I am, whilst Laura is in the chat. Her sound does not work, so she can't hear what I'm saying, which is probably helpful, and she can't say anything that anyone else could hear, so that's a bit of a shame. So stuck with me, I'm afraid, for this section. Settlement agreements, though, this is if all's gone well in the protected conversation or without prejudice discussion Nick's just talked about, and in the planning session I alluded to earlier, this should be the easy bit. It's where you just tie it up and make the legally binding agreement. And we call the slide settlement agreements, but as the first bullet point says, there's two ways to reach your legally binding agreement that waives the claims that you probably want to waive, whatever the context is of the dispute. And that's the classic settlement agreement, as we call it, and the COT3 agreement, or COT3, reached via ACAS. I suppose that's the key difference. The ACAS agreement is binding when the ACAS conciliator says so, having had both parties agree to the wording and confirm that to the ACAS conciliator, whereas the settlement agreement is agreed when the contract is, usually when it's signed by both parties. So the ACAS method inevitably involves a third party, although you could argue the settlement agreement involves extra parties because the employee needs to get an independent advisor who won't have been in the discussions prior. So to a certain extent, it's swings and roundabouts is what the best one is in any given case, but there are sort of advantages and disadvantages to both. The slide sets out some of the things a settlement agreement must be in writing. It must relate to a particular complaint. So the agreement has to identify specifically what claims are being waived. If it just said it's in all and any claims full and final settlement with no reference to actual specific statutory legislation like unfair dismissal or discrimination, and as you'll see in settlement agreements, it's usually quite specific that this is why. The employee must have received independent legal advice. I alluded to that earlier. And their details must be noted in the agreement. And one thing that often happens, as well as their name and usually practice or firm or wherever they are being associated, or trade union, if that's the case, because trade unions accredited advisors can fall within the category of independent advisor as per the legislation, and they usually complete a certificate. That's just to reassure the employer that they have in fact given the advice, and so the person has received it, and therefore the waiver of claims works. Pros and cons. Well, the advantage of settlement agreements is usually that, as I said, there's no third party, so you can usually control the speed a little bit better. You aren't reliant on ACAS to confirm whether there is or isn't an agreement, and ACAS can be difficult to get hold of or busy. I mean, it's a bit of a mixed bag. Some ACAS conciliators are brilliant. Some of them are understandably bombarded with work. The other thing about speed with ACAS is sometimes if you're involving them in a new matter that isn't an employment tribunal claim, it can take a while for you to get a conciliator on board. So if you're in a rush, then sometimes settlement agreements are a better option. But an advantage of the ACAS process is that the employee doesn't need the independent advice. So that means that saves time because they don't have to arrange an appointment getting it, and potentially saves costs because you'd have to pay for it potentially. And also, there can be situations that I'm sure some of you on the call have faced where the deal is all agreed, but then the employee goes off to the independent advisor and then based on the advice seeks to renegotiate the deal. That could still happen when they speak to ACAS, but ACAS have a different role to the independent advisor in that ACAS is neutral. So whilst they might explain to the employee what the proposed COT3 terms say and give them information, they're not going to be telling them it's a bad deal, don't do it, or at least they shouldn't be. So that there's some pros and cons to think about. But in terms of the content and the extent of the waiver, it's largely similar. Most things you can do in a COT3, you can do in a settlement agreement and vice versa. There's a few exceptions on niche claims that don't come around very often. I won't go into that now. Settlement agreement checklist. I think if we haven't already put it in the chat at some point during this call, we might put it in now. We have a checklist. That's just a tool that we've developed. It's not complicated. It's just one to facilitate a smooth transition from what's agreed to a settlement agreement where we provide it to usually the employer client, they fill it in, we can then produce the settlement agreement, and it minimizes the sort of toing and froing. Or what about the legal costs contribution? Is there one? Is there a company car? What does your contract say? So it makes the whole process more efficient. As the second bullet point says, check the employee's contract to employment. I mean, that's relevant for a whole load of factors, a lot of which I mentioned before. Notice periods, notice pay. It'll be relevant to assessing the tax position. It might be relevant to terms relating to, say, confidentiality. It might be that the contract to employment already has completely extensive confidentiality restrictions, and therefore all the settlement agreement needs to do is remind the employee that they remain in full force and effect after employment ends. It might be that the contract is very, very thin and has very little, and that you want to introduce new confidentiality restrictions or to beef up the ones that are in the contract, and we can do that. But first we want to see what the existing obligations are to see whether they're sufficient. Does the agreement reflect the actual position intention? Well, hopefully it does, and that's why we want to get the checklist. We want to ensure that the agreement reflects what everybody wants, and that will usually mean it will move more quickly and seamlessly to a conclusion. And then the final bullet point, old templates. They're a bad idea for a number of reasons. I've seen sort of some horror shows where people have provided employee an agreement with a different employee's name in it. That's obviously embarrassing and creates a bit of a data protection problem. But the other issue with old documents is it might have references to legislation that are outdated. It might have mistakes, or precedent documents evolve all the time. So if you've taken out certain clauses from a precedent document because they didn't apply in one situation, the new situation you've come to, they may very well apply. And if you're starting from a template that doesn't include them, you're probably not going to. So I'd be very careful about sort of using old documents and recycling. It's a sure way to miss things. That's a very brief section on settlement agreements, and we're going to hand back to Nick on other things to consider.
Thanks, James. So just to finish, we thought we'd highlight a couple of other things that are relevant in these situations when you're managing exits, and in particular relating to employees who might also be directors or shareholders. So HR professionals often have the unenviable task of helping manage the exit of a very senior person within the organization, sometimes even their boss. And actually, because those people are very senior, it can sometimes be more complicated to manage that process than perhaps what you might describe as a normal employee, if that's really a thing. And essentially what I'm flagging here is that directors and shareholders, there are other issues to consider. And that's partly because they will nearly always be employees, but they will also have other rights and obligations as a result of their director or shareholder status. And things like, for example, the Companies Act might apply to them and create certain obligations on the employer to manage their removal as a director, for example, or as a shareholder in a different way, and sometimes even in a way that isn't quite helpful, marrying up with employment law. So, for example, removing a director might require a resolution at a meeting, a directors meeting, essentially, or termination payments being paid to directors may need shareholder approval. And actually building in a process that allows for that and still allows you to be compliant with employment law might be tricky sometimes. And that's just worth keeping in mind. There are special rules that apply to public and listed companies, and we're not going to go into masses of detail there, but for most sort of run-of-the-mill limited companies, these kind of issues might be something that you do need to consider if it's a director or a shareholder employee that is leaving. The other thing to keep in mind when you're managing those situations is whether the company has articles of association or a shareholders agreement, because they are documents that might well cover some of what needs to be done in order to manage their exit. And certainly if you're an HR professional and you're not sure whether your company has those in place, it would definitely be worth going back and checking that, because actually if they're not in place and they haven't been drafted in a way that is helpful for managing those situations, often you can be relying on provisions within the Companies Act which set a sort of default approach in those things and aren't necessarily always that helpful. We often work very closely with our corporate law colleagues on those kinds of issues because it relates to the operation of the company as well as to the employment law side, and usually we kind of dovetail together to come up with a plan for a client that allows you to manage both sides of those things well and achieve the objective that you're looking at. But again, just to flag that there are more, there's more to that if that's the situation. It's slightly outside our area, which is why we work with those colleagues, but it does come up fairly regularly in those scenarios. The other thing that often is the case with senior individuals like that is that you may well be more often relying on the sort of protected conversational without prejudice discussions that we were talking about, as opposed to a formal process. So it's rare, I think, although it does happen, that you would have a performance management process that goes on for an extensive time for a chief executive, for example, or a redundancy process, that you're putting the FD through, or those kind of things, and therefore discussions about the fact that things are not working out as they should be, and can we come to some sort of deal for that person to leave, are, I think, more common in those scenarios. Again, documentation can be really important there. So if those director exec roles, if they're signed up to service agreements or employment contracts, that can be helpful in terms of understanding how we best manage those situations. If they don't, have those in place, then actually things can get particularly tricky. So it's worth, again, often those senior exec teams are the ones that are missed sometimes by the HR guys who think, okay, well, we've looked after everybody here, we've got everything in place, but actually those senior execs have no contractual documentation at all regulating their employment. And again, that can be really, really important. So do check that if you are concerned, on that side. The other thing that sometimes happens is with the more senior execs is that they have long notice periods, and James talked about the benefit of garden leave and that kind of thing, and that might well be an appropriate way to utilize garden leave, where actually you have a long notice period, you're concerned about a very senior and important person going to a competitor or that kind of thing, because they have specialist knowledge or detailed knowledge of the workings of the company. Actually, the benefit of that long notice period might well be that you can put that person on garden leave for a period of time, or negotiate something relating to that notice period. And of course, the relation with post-termination restrictions or restrictive covenants, which again might be in the service agreement that the exec is signed up to, might be a point of negotiation too. So it might be that you want to impose new clauses that restrict what that senior person can do after they leave as part of the settlement agreement. That's possible to do. It might be that there's an agreement to waive some of those things so that the person can go work somewhere in particular that they perhaps were restricted from doing so. Or it might be that actually you're asserting the fact that those restrictive covenants continue to apply as part of that settlement agreement. And again, that's not at all unusual, where you're effectively getting the exec to confirm again that they understand that they apply and that they won't breach them. And then I suppose the other thing that we often see negotiated into settlements with the more senior people really covers the kind of mechanics of them leaving and how that's going to be announced. It's almost the comms side of things. So what are we going to tell colleagues? What are we going to tell customers, suppliers? Do we have to make a announcement to the market, even in terms of the fact that this person is going, and doing that well and agreeing it with the employee that's leaving is particularly important. And often we see that kind of thing scheduled to a settlement agreement so that everybody's clear on what will be said and when. But again, getting that right in order to minimize risk to the business is really important. Finally, on this section, the other thing that comes up pretty regularly are things like share incentives, so long-term incentive plans, that kind of thing, bonuses, and how they will be treated at the point the person is leaving. And often, because the senior people are generally better paid, have more generous share incentives or bonus schemes, there can be a lot of money involved in these things, and the employee, director, shareholder exiting will pay particular attention as to what's going to happen with these. And again, sometimes it gets missed. I think we fairly regularly have situations where a client will come to us and say, this person's going to be leaving, we've agreed a deal, and we'll ask about these things, and they might have been missed, they might not have been considered, or it'll be the case that the individual raises and say, well, what's going to happen with my bonus, and what's going to happen with my shares, or whatever it might be. So again, as James was saying earlier, planning ahead and being clear as to what we're going to do with those things is really important. Often there will be documents in place which regulate what happens. Sometimes that's the service agreement or the employment contract. It might be a separate written bonus scheme. It might be share scheme documentation, that kind of thing. And again, not the sort of thing that we always day to day consider as HR professionals, but being aware of the impact of that person leaving and how that interrelates with their bonus or their share incentives or shareholding is really important too. Things like good leaver, bad leaver status is the sort of thing that's often set out in those documents, and will determine what happens with those payments to those individuals. If the person's also a shareholder, It's also worth thinking about what will happen with those shares. Are they just going to keep them? And although they're not a director or a employee of the business anymore, they'll remain a shareholder. Is that okay? Are we all right with that? And often that's not the case, and a clean break is what is being looked for. But what's the actual process for getting those shares back? Will they be allocated to other individuals? Is the company taking them back? What will the value paid for those shares be? Have we had valuations from accountants? What will the tax implications be around that shareholding? All of this really quite complicated stuff that, again, doesn't really sit within our remit, but comes up regularly, and we would consult our corporate colleagues again as to, okay, this person has this shareholding, we would like a clean break. Can we get the shares back? What's the mechanism for doing that? How might we treat that, those shares in terms of value and tax and that kind of thing? And again, can get massively complicated if planning ahead, isn't done properly. So just to flag those as kind of extra complications that can sometimes come up, and that you really should get to the bottom of before starting those discussions with those more senior people. And then pretty much finally, the other thing that we'd thought was that we've talked lots about unfair dismissal, and that is really the key element that comes up when you're managing employee exits, and I think will be more relevant if Labour do introduce the day one unfair dismissal rights. But there are other claims just to keep in mind, and we thought it would be remiss of us not to mention them at all. But discrimination, again, has been mentioned on and off through the session, and whistleblowing is the other one. And I think the key there is that there is no length of service requirement for either of those things. So claims can be brought early in employment, even before employment in theory, and therefore those can be live issues very quickly. And particularly in circumstances where there is a dismissal and the person alleges that it was for a discriminatory reason or because they blew the whistle on some wrongdoing. And of course, loss of earnings awards are still possible in those scenarios, and the cap that I mentioned earlier on that compensation can be lifted as a result of there being a discrimination claim. But also you can get injury to feelings, which again, many of you will be familiar with, but effectively compensation linked to loss of earnings to compensate the individual for hurt feelings as a result of the discrimination. The other thing you'll notice on the slide there is something called interim relief. And I just wanted to highlight that because we've seen a few of these again recently. They're pretty rare, but they are claims that an individual can bring where they say they've been dismissed for blowing the whistle. So I'm trying to keep it in headline terms. But the frustrating thing, I suppose, from an employer's perspective is if someone ticks the interim relief box, essentially, and brings a claim on that basis, that the tribunal will then list a hearing, usually within 7 days, for the employer to be in tribunal with the employee to hear a kind of preliminary assessment of whether, and the legal test is a slightly strange one, there's a pretty good chance that the person was dismissed as a result of blowing the whistle. And that basically means that the usual process of waiting a year, 18 months, even 2 years to be in a hearing on a claim is massively fast forwarded to 1 week, which obviously can create a fair amount of panic and does usually result in a significant amount of work in a very short period of time to get prepared properly for that. The reason that that's important is that if the tribunal finds for the employee in that scenario, they can award or make an award that the employer pay that individual's salary until the main hearing. And as we've talked about, that can be a little while off. The idea of this is to protect whistleblowers. Essentially, that's the policy behind it. A lot of employees don't know about it, and we don't kind of shout from the rooftops about it clearly because we tend to work for employer clients. But I suppose our warning to you is if you get one of those, deal with it quickly, take advice, whatever it might be, because you're likely to be in tribunal pretty quickly. So that covers the kind of other claims. And just to finish that off, we have had a few good questions as we've gone through. We do have just a couple of minutes. We've pretty much finished bang on time as scheduled for 11. If anybody has any other questions, feel free to fire them into the chat, or if I don't know whether it's possible to unmute, it may be that you can unmute as well and fire them our direction. But thank you, Leslie, for the feedback. Good to have you along. We'll give it a few minutes before we end the call, just in case there are any questions. While we're doing that, for those that missed the beginning of the call, we have a few things on offer. We have a free employment contract review, checking legal compliance of your contracts. Again, as I mentioned at the beginning, there were some changes as a result of the Good Work Plan, and we're still seeing some template contracts that are not up to date and therefore not legally compliant for new starters. So we'd happily have a look at that for free and let you know what can be improved. We're doing training like this for clients on a pretty regular basis, both in person and online. So if that would be useful for your teams, particularly with the unfair dismissal changes coming, we do really believe that managers are going to need to be upskilled on how to manage dismissal meetings, essentially. So we run some good sessions for those guys. We have the East Midlands HR Network. Again, there is a link to that in the chat, and it wouldn't be one of our webinars if we didn't promote the HRD Talks podcast. Again, there's a link in the chat, and you can ask your smart device to play it for you, or find it on your podcast provider of choice. So we'd love to have you check that out and let us have any feedback. I've seen lots and lots of thank yous, which is great. We're really pleased it was useful and everybody was able to join us. If there are any questions, obviously pop them in there quickly or pick up with us separately. That would be great. Thanks everybody for joining us.